and go ahead.
Mr. Chair, members of the committee, my name is Leili Fatehi, and I represent Friends of the Mississippi River, a leading citizen-based organization that works to protect and enhance the Mississippi River and its watershed. Thank you for the opportunity to speak today. This bill, especially as amended, serves a single outcome, if not goal, to obfuscate public transparency and accountability of decision-making to protect our environment, natural resources, and public health. And in doing so demonstrates an incredible disregard for the very fundamentals of administrative law and process and even constitutional law, which will come with a very expensive price tag, majority of which will go to lawyers, as I will explain. Under the A10 amendment, this bill essentially encourages people to preemptively challenge the MPCA over regulatory decisions that they haven't yet made and requirements that they haven't yet imposed, and which they very well may not impose in the future. And the reason that they may not impose those requirements is that under the Administrative Procedures Act, the proposal of an action by an agency is itself a mechanism that triggers extensive requirements for public notice, comment, and input, including comment and input on the agency's science by members of potentially affected industry or otherwise regulated entities, including cities. By law, the agency is required to consider and respond to comments from both the public and from regulated entities. And the reason this exists is so that if and when the agency makes a final decision, that final decision is responsive to the issues and concerns that were raised before them by others. It also means that an agency's final action may and often turns out to be different than what the agency had initially proposed. So for one, it's bad policy to move all of this into an adversarial proceeding very early in the process because it undermines the ethos of collaboration between the agency and regulated entities as well as the public. And what we've been hearing, I've been hearing in this committee and a lot of others, is that people want the agencies to spend more time working with them rather than against them. This makes that much more difficult. Second, encouraging an adversarial process so early in the process comes with an expensive price tag, both for the challenging parties and for the MPCA. It makes it an upfront cost for the agency and for regulated entities to pay for a challenge to a decision that is as yet unmade, rather than making that an expense that's only paid if regulatory decisions are made following considerable formal and informal opportunities for regulated entities and the agency to come to a mutually agreeable outcome. Rather than going to lawyers, this money could be better and more efficiently spent by the agency if it were used in the course of, say, reviewing science, engaging in deliberations towards reaching a final decision, or to provide, for example, technical assistance, as we've been hearing is a need. As a related matter, this bill, especially as amended, may create a significant chilling effect on the MPCA carrying out its required responsibilities under both state law and under the Clean Water Act if the agency fears having to go through a lengthy and expensive adversarial process each and every time it preliminarily considers a new or modified water quality standard or the like. And if this were the case, it would also undermine public transparency and accountability of the MPCA's process, because the agency might be inclined to conduct its deliberations about actions it's considering behind closed doors. I also want to point out that there's nothing in the status quo that prevents a regulated entity from petitioning for a contested case hearing on a draft agency decision. Even if it's not explicitly authorized in statute, that right likely exists, and courts have demonstrated that it exists under the Administrative Procedures Act. And if I'm able to figure that out, there's no way that it's too opaque for the regulated entities to know that as well. Yet the reason nobody's been choosing to do it is because it is an inefficient and counterproductive approach. And even if a regulated entity gets a contested case hearing, it's been very difficult for them to prevail because ALJs are remiss to reject an agency decision that has not yet been made. And CGMC certainly has amply availed itself of contested case hearing processes and repeatedly been disappointed at the outcomes. When ALJs have had the opportunity to review agency science against criticisms raised by CGMC and its hired experts, the ALJs have found in favor of agency science. The same thing has happened when CGMC has brought its complaints before the Court of Appeals. So now what this bill does is it flips 130 years of administrative law and process on its head just so these individuals can get their way. The bill basically displaces, and especially under the amendment, displaces the entire agency rulemaking process and shifts it to be entirely under the control of an ALJ with no subject matter expertise to engage in highly technical scientific analyses, but also with far less accountability to the legislature and to the public. For more than 130 years, we've acknowledged that rulemaking, agency rulemaking, is a statutory delegation of legislative authority. And as such, the APA provides for these procedural requirements for notice and comment, since we also have to have notice and comment for legislation. This bill, as amended, delegates rulemaking authority to administrative law judges, who are executive branch officers, subject, however, to many judicial branch requirements. And it's not clear what transparency or accountability obligations, if any, ALJs have. And as a related matter, and this is my final point, for more than 70 years, courts have upheld this principle that agency rulemaking is a statutory delegation of legislative authority by rejecting agency decisions when they're unconstitutional or in excess of an agency's statutory grant of authority, or when arbitrary or capricious. And under this longstanding approach, there is a clear and direct line between the express intent of the legislature, as codified in statutory language, and the permissible scope and limits of agency rulemaking authority. No such connection exists between the will of the legislature and the will of an administrative law judge. As such, were a petitioner to challenge a rule promulgated by an ALJ, there's no norm or basis for a review court to give effect to the legislature's wishes. And in fact, Minnesota review courts apply an abuse of discretion standard to administrative law judge decisions. And per the Minnesota Supreme Court, the legislature can't change the standard of review. And this is an even more deferential standard than that which is afforded to agencies. So if the proponents of this bill have a concern that courts are deferring too much to agency determinations, this bill does nothing to fix that. It potentially puts them in worse bargaining power. Thank you very much.
I have a question to the testifier. You represent the Friends of Mississippi. Are you a board member, or
No, I'm.
I know we've met several times over the course here.
I'm a legislative consultant.
Okay, you're a consultant. Okay. I must say that I appreciate your testimony and have because it's here. It appears that you certainly know the issue very well when you testify. But I do take homage, and I know the chairman very well. Excuse me, I know the author very well, and he knows me. And you know, sometimes we throw out those comments like behind closed doors, and I really take offense to that kind of stuff when it's just used willy-nilly, because there isn't the author or myself that would allow anything to go on behind closed doors that wouldn't be exposed to the public. So just be careful with that.
Mr. Chair, members, my apologies if I misspoke and suggested that the work of the legislature would happen in any way behind closed doors. What I meant was that there are requirements in the Administrative Procedures Act that are intended to make the agency's administrative record one that is transparent and accessible to the public. And I believe that there are mechanisms in this bill, and especially under the amendment, that may have the effect of undermining some of those mechanisms that are supposed to ensure the transparency of a agency's transparency and accountability. My apologies again.
Thank you. Thank you. Transparency is very important. I know to the committee as well as the author, and I'm rest assured. I think the MPCA is good with that as well. So, Any questions of the testifier, members? Ms. Gauthier? I'm sorry.
Thank you, Mr. Chairman,
Oh,
and good morning, members.
I'm sorry, I missed one. Mr. Matthews, Senator Matthews.
Thank you, Mr. Chairman. Very briefly, thank you for your testimony and for pointing out a couple of things. Just to begin with, number one, your comments about how basically lawyers are the winners in a lot of these areas, and hopefully you can work with different judicial reforms that will be needed then to prevent that from happening. As a fellow law school graduate myself working in that field, that has been a problem in numerous situations. And I'm also pleased to read and hear your testimony about how detrimental rulemaking by judges can be. There have been a number of areas where we've been wanting that position to be recognized, and that's definitely the case here as well. But I do want to ask, you've pointed out how judges do not have subject matter expertise in this area of environmental review. So I'm wondering, what subject matters do judges have expertise in?
Mr. Chair, Senator Matthews, judges have expertise in terms of evaluating questions of law and assessing fact against them, but I would say that even the staunchest opponents of judicial deference do not go so far as to say it should be within the purview of a judge to make a de novo determination of scientific fact.
Follow-up?
Quick follow-up, Mr. Chair. Thank you. Would you then agree with the position that perhaps we should have legislative approval over proposed rulemaking from agencies?
Ms. Fatehi?
Mr. Chair, Senator Matthews, I would not go so far as to say that because I think that there are constitutional issues with legislative approval of agency rules stemming from both presentment issues and I see it as being legislation without going through the legislative process. Furthermore, I think that the legislature has, under the status quo, authority to affect rules or rulemaking that it doesn't like, and that is by changing the statutes that grant an agency its rulemaking authority in a particular area, or if an agency passes a rule that the legislature doesn't like, the legislature can pass a statute to repeal that rule.
Okay. Members, any other questions of the testifier? Okay, we'll move to